Hearing in the matter of King and Sheikh and others.
Yes, Mr. Smith.
My Lord, my ladies, I represent the appellant in this appeal from the Court of Appeal Criminal Division on the 25th of January of 2025. The representation in this appeal is as follows. Mr. Green, King's Counsel, leading Mr. Connor Quinn for the first respondent. Mr. Abdul Iqbal, King's Counsel, leading Mr. Hendon for the second respondent. Mr. Alistair MacDonald, King's Counsel, leading Ms. Colley for the third respondent. And finally, Ms. Colborne, King's Counsel, leading Mr. Simeon Evans for the fourth respondent. May I open this appeal by drawing the Court's attention to the certified point in this appeal, which is at page 106 of the key document bundle and the main hearing bundle, which reads as follows. Whether Section 51B3 of the Domestic Violence, Crime and Victims Act 2004, I apologise. Just wait.
No, it's okay. I've got this well in my mind. Thank you very much.
Sure.
Yes.
Which provides as one of the conditions of criminal liability that the act occurred in circumstances of the kind that D foresaw or ought to have foreseen should be construed broadly so as to include any deliberate and harmful act occurring in the context of previous domestic violence that's known to have been perpetrated against the victim within the same household. Yeah. And we do attach significance and invite your Lordship and your Ladyships to attach significance to that word context.
Is it your position that that question should be answered in the affirmative?
It is, my Lord. We will be submitting that that question should be answered in the affirmative, and in the most simple terms, that the error for which we submit the Court of Appeal was responsible was in attributing the interpretation of Section 51D3 to the act which caused serious physical harm rather than the circumstances and whether they were of a kind which the defendant foresaw or ought to have foreseen.
Now, the word include appears there, include any deliberate, etc. Are you saying that it's necessary that there has been previous domestic violence?
No, I'm not, no. Lord. I'm not saying that it's necessary. In fact, I will be taking the Court to the most recent decision of the Court of Appeal in Jamal, which has made it very, very clear that awareness of the risk of serious physical harm is necessarily, in terms of the words of the statute, a coterminous with the unlawful act which causes serious physical harm.
So you're saying that it's not the risk of serious harm doesn't necessarily arise from some previous serious harm?
Not necessarily, and I will be taking the Court also to the decision in ATT, which made it clear that there may be two sets of circumstances. Antecedent acts of serious violence may be sufficient to create an awareness of the risk of serious physical harm, but following the words of the statute, the awareness of the risk must coincide with the unlawful act because of the words at the time. But there are many cases, and we shall come to this if we may in a moment, there are many cases in which the prosecution are unable to establish the events surrounding the unlawful act. Yeah. And then it is necessary for the prosecution to point, if they can, to antecedent acts of violence which created the awareness of the risk.
But is it necessary to have an antecedent act of violence, or Could you have antecedent threats?
Well, my lady, you could have antecedent threats.
Right.
If there is a threat within the household that a child or vulnerable adult is going to be assaulted, and that threat is taken very seriously, so as to create an awareness of the risk, then that part of the section is, we submit, satisfied.
As long as the act, which is the unlawful act, is the result of that risk having eventuated.
Yes. In other words, the awareness of the risk is awareness that serious physical harm may be inflicted, and Section 1D3 goes to the point of foresight that that risk has now eventuated. So may I just briefly touch upon the decision of the Court of Appeal. The decision of the Court of Appeal resolved the appeal in the respondent's favour, while accepting as accurate the construction of Section 5(1)(d)(3) of the Act as contended for by the prosecution and as reached by the trial judge, Mrs. Justice Lambert, but concluding on the facts of this case, undisputed as they were, that the respondent's application that the case should be withdrawn from the jury should have succeeded. The Court of Appeal accepted that Section 5(1)(d)(3) of the Act, these are the words taken from the judgment, delineates a non-perpetrating defendant's culpability by reference to the circumstances in which the risk of serious physical harm to the victim has occurred, and that the question is whether it was, quote, of a kind, unquote, which was or ought to have been foreseen by the defendant.
Sorry, where are you reading from?
I'm so sorry, I was just reading some brief notes of my own.
Oh, but you said it, this is what the Court of Appeal said.
Yes, I'm so sorry. Paragraph 28
Thank
of the
you.
judgment,
Yeah.
which is key document bundle in hard copy form at tab 8, page 102. I do apologise. The reason for allowing the appeal was that expressed in paragraph 41 of the judgment, page 104 of the key document bundle. And I'll take the court, if I may, to that at page 104. We are persuaded that in the particular circumstances of this case, the submission of no case to answer as regards the counts of causing or allowing the serious physical harm of a vulnerable person should have succeeded. The administration of a minimal quantity of glimepiride, even if established to be with unlawful intent, was so utterly different from the infliction of the sacral injury that had occurred shortly beforehand, and which the prosecution relied upon as giving rise to the foreseeable risk of serious physical harm. But we doubt that a reasonable jury, properly directed, would conclude that it occurred, quote, in circumstances of the kind that D foresaw or ought to have foreseen. We stress that we do not thereby suggest that a defendant will necessarily escape liability if the act which gives rise to the foreseeable risk is of a different category to that which causes the victim's subsequent death or serious harm. All cases will be fact-specific. In this case, for example, if Ambreen, the victim, had been forced to ingest a caustic agent, such as caused her sacral injury, then the misuse of the same or similar caustic agent could be evidence from which a reasonable jury may properly conclude that the act had been committed in circumstances of the kind that the defendants foresaw or ought to have foreseen.
I mean, you may be coming to this, in which case don't let me take you out of your way, but it seems to me that what needs to be foreseen is the act rather than the circumstances. It's the circumstances that, because of the risk, cause D to foresee the act. Is that right? It seems odd to say that D is foreseeing circumstances of the kind. I would have thought what D needs, well, what D needs to see is the circumstances, is the act.
With great respect, we would not accept that proposition. It's our submission that what must be foreseen are the circumstances in which the act occurred, and that those circumstances need not be other than of the kind which the defendant had in contemplation. So those general words, of the kind, are added to widen the approach of foresight in relation to the circumstances. What must be foreseen are the circumstances in which the act occurred, not the act itself. That is our primary submission in this case. And so, if one entered into a situation whereby one was focusing upon the act and what was foreseen in terms of the act, there would be a wide range of cases in which different forms of violence were perpetrated upon the victim, where one is relying in a particular case upon antecedent acts of violence. And one would then be in a position whereby one would be interpreting the Act of Parliament on the basis that the jury's function would be to determine whether that act was different and whether it was materially different, utterly different, or significantly different to that which formed the antecedent act of violence.
But in the paradigm case, which the Court of Appeal mentioned, where one partner knows that if the baby doesn't just cries all the time, the other partner will try and stifle it, for example, right? So that's happened before. What you have to foresee is that if circumstances of the same kind, namely the baby crying the whole time, occur, you must try and protect the baby from being stifled by the partner. Isn't that how it's supposed to work? So it's not that you foresee the baby crying, you foresee that if the baby cries, your partner is going to injure it. Or may injure it.
Yes. The circumstances which give rise to awareness of the risk and leading on then to foresight of
injury.
The act. The circumstances in which the act occurs are principally these: that within a domestic context, if there has been threats of violence to a child when crying, threats or violence to a child when one partner of that relationship is intoxicated, then the defendant may foresee, looking at section 1D3, that those circumstances are the kind in which the risk of further violence and causing serious physical harm may arise once more. Once a defendant has awareness of the risk, subsection 2 requires or imposes on the defendant an obligation to take steps to protect that child from the risk. So that's 1 and 2 satisfied. And then we submit that there's a further element, the safeguard contained within 3, that not only must there be awareness of the risk coterminous with the unlawful act, not only must there be the duty to take steps then to protect the child or vulnerable adult, but then in addition there's the further safeguard that that defendant must have foreseen the circumstances in which the act occurred. And of course that does to a degree relate back to the history of the way in which a child has been treated within the household. So that's the way we would approach that.
I mean, the counter-argument being put, as I understand it, to your main submission, is that this would render the earlier requirements OTOs.
Yes.
You would almost automatically be satisfying 5D 3 if you've already satisfied the first conditions. Now, I noticed that in your submissions at paragraph 14, you have a qualification, because you say, other than in wholly exceptional circumstances.
Correct, yes.
Which means that you actually don't think the certified question should be answered in the affirmative, because you want to say, well, there's got to be a qualification for exceptional circumstances. Or am I misunderstanding?
It may be that I'm misunderstanding. Would you forgive me? The qualification we impose in relation to that is in response to the argument that Section 1D3 would be rendered OTOs if all that is required is an awareness of the risk accompanied by a failure to take steps within a domestic setting. So what we have sought to grapple with is the important question for the purposes of this appeal, which with respect to your Lordship is important, and that is whether the provision in 3 is in fact OTOs. We will be drawing attention, if we may, the attention of the Court to the fact that during debate in the House of Lords on the 9th of March of 2004, on behalf of the government, interestingly, Baroness Scotland introduced the example of an elderly grandmother who may be a little confused and unable to foresee the circumstances in which the act occurred. And it is plain in our submission.
But that would be covered by the earlier. It wouldn't be reasonable to foresee the risk.
Well,
if you're talking about somebody who has not got the capabilities of a reasonable person.
I agree. One could mount the argument that the elderly grandmother would be able to avail herself of the defence in 1, that her mental capacity was such that she was not aware of the risk. But may I pose rhetorically at this question, what of the elderly grandmother who in fact sees violence being perpetrated in front of her and is aware of the risk regardless of her mental capacity? She might then avail herself, depending on the circumstances, of the defence in limb 2, but she would be able to avail herself of the defence on the example introduced by the government, that she did not foresee that that risk would eventuate. And what we are submitting is that Parliament introduced these 3 safeguards into what otherwise might have been a set of circumstances which would easily give rise to criminal liability.
No, I understand that. The question is whether it's as broad as you are submitting.
Yes.
And in fact, as the certified question would seem to take a very broad interpretation.
It does.
Now, when you look at your submissions, as I understood it, you have a qualification about exceptional circumstances. I mean, I may have misunderstood.
I may have done it.
But I thought that was what you were saying at paragraph 14.
Well, that is what we're saying. What we're saying at paragraph 14 is once awareness of a significant risk of serious physical harm has been decided against a defendant by a jury, and once that defendant has failed to take reasonable steps to protect the victim, it's difficult to see any circumstances in which the defendant would not have foreseen the risk eventuating, except, and we've introduced the caveat or proviso, except in exceptional circumstances, and that would depend upon the findings of fact and the specific circumstances of the case.
But what that seems to me to mean, but forgive me if I'm wrong, that once you've satisfied 5.1d1 and 5.1d2, and you're in a situation of an unlawful act causing serious physical harm that within the domestic setting, you will satisfy 5d3 except in exceptional circumstances.
That's our submission. You will satisfy it.
Yeah, except, you say, in exceptional circumstances.
Yes. And those...
But what are these exceptional circumstances? Oh. And doesn't that mean, I come back to the point, that the certified question has to be at least qualified to that extent?
Well, it may well have to be qualified to that extent, but...
Well, sorry, I mean, what is your submission? I mean, are there exceptional circumstances or not?
Yes. They may have...
Are you able to help me as to what they might be?
Well, those might be those within the example that I've just cited. There may be a situation in which a defendant has been found culpable in respect of 1 and 2.
Yeah.
But our submission is you then have to look, or a jury has to look then, at the issue of foresight, obviously.
Yeah.
Once the jury looks at the issue of foresight, it will be unusual, or shall I say, in most cases, the requirement of foresight will be satisfied. But what Parliament has done is provide an additional safeguard to permit the jury to examine any cases, or exceptional cases, which might arise.
I understand that, but your opponent is effectively saying, if you read it as broadly as you have done, without your exceptional circumstances qualification, you are rendering 3, the safeguard given by Parliament, otiose.
Without those exceptional circumstances.
So everything would seem to turn on what these exceptional circumstances might be.
I would submit not everything. As far as the exceptional circumstances are concerned, it would be unreasonable to ask a prosecuting authority to anticipate circumstances of fact which might avail a defendant who is seeking to take advantage of limb 3 but has already been found to have been culpable in respect of limbs 1 and 2. It is simply impossible to envisage the circumstances which from day to day appear before juries that they have to consider.
But can I give an example? I don't know if it might help illuminate it, from a case that I remember in front of a jury. Say you have a toddler who is raped and suffers quite a serious physical injury as a result of a rape. Then you would have a child suffering serious physical harm as a result of the unlawful act of a person who, we can assume, say it's a stepfather, was a member of the same household and had frequent contact with the child. Okay, so 1 is satisfied. 2, the defendant, C, at the time there was a significant risk of serious physical harm being caused to the victim by the unlawful act of such a person. Well, there might have been such a risk. I mean, if a person, for example, was part of a paedophile ring, then there would no doubt be a significant risk. But when you go on to D3, D might have been aware of a significant risk of serious physical harm being caused to the victim by the unlawful act of a person in the household. If, for example, the stepfather had been knocking the toddler around and if there were bruises or perhaps a broken arm or something of that kind.
Yes.
So you could say the defendant ought to have been aware of the risk mentioned in paragraph C, because the risk of of the broken arm and so forth would satisfy that test. But the act, the unlawful act that we're actually concerned with, the rape, couldn't be said to have occurred in circumstances of a kind that the defendant ought to have foreseen, unless the defendant was aware of the paedophile behaviour of the stepfather.
This brings me back, with respect, if I may, to this point, that the awareness of the risk must be coterminous with the unlawful act. In those circumstances, what the...
well, you have to read that into the Act. It doesn't say that, does it?
Well, subsection C, I believe, subsection C makes it very clear, when combined with section 5(1)(d)(1), that the awareness of the significant risk should coincide with the unlawful act by the words "at the time." So, may I come to the example which Your Lordship asked me to consider?
Yeah.
There's no reason in those circumstances why foresight of the circumstances could not be established against a defendant. Because if one is looking at the circumstances in which the unlawful act is perpetrated, and the defendant has a significant, awareness of a significant risk of serious physical harm at that time, that defendant will be faced with activity on the part of the person in question, which triggers a responsibility under subsection 2 to intervene and protect that child, insofar as it is reasonable to expect that person to do so.
So you would say that this offence would clearly cover Lord Reed's example?
I would.
No.
And I would expect it to. I think I'd be very surprised if it didn't. So to that extent, we're ad idem. What I'm looking for is a situation on the other side of the line that falls within your exceptional circumstances. Because the answer you've really just given us is, well, there's violence of a type already going on in this household. It's the same household. You'd expect domestic violence, or you've got a risk of that, and therefore you satisfy 1D3. And the counter-argument being put to you is that that is rendering 1 and 2 superfluous. It's rendering 3 OTOs because of the earlier 2 provisions.
I will address this point, if I may, in this way. Parliament could, of course, have legislated on the basis of 1 and 2 only.
Yes.
In other words, a situation has arisen at the time of the unlawful act.
So we need to give some content to the third, because it could have just been 1 and 2. Now, what I'm suggesting to you is the counter-argument that you really need to face, as I understand it, is that they have put in that provision for a reason. It's narrowing what you're suggesting is the correct interpretation. Otherwise, it's got no function. So what is the answer to that? And you seem to accept that it can't be as broad as automatically, in effect, a situation where you've got violence in a domestic scenario because of your exceptional circumstances. But I was hoping you might be able to help me as to what those exceptional circumstances might be.
I was hoping I could. But all I can submit is that it's quite clear when your lordships consider the debate on the 9th of March 2004, when the bill was considered on report, that there was concern that the offence as drafted was too wide in the sense that people who did not deserve to be convicted might fall within the net. that example that I've referred to that was taken by Baroness Scotland in debate was intended, I submit, although I can't go further than the words of the Hansard, was intended plainly to allay any fear that there might be circumstances in which a defendant could be wrongly convicted when they did not actually foresee the circumstances in which the act occurred. And I would put it this way, that it was a safeguard that Parliament introduced. And I wonder if you would just give me a moment, because I haven't quite got this up on the screen. But if we could go to the Law Commission's
just before we go there, in the Khan case, as I understand it, a distinction was drawn between a situation where the first example of violence is punching and the second is killing by a knife.
Yes.
Now, as I understood it, the Court of Appeal was implying that that might fall outside this provision. Now, would you accept that or not?
I would put it differently, if I may. I would submit the Court of Appeal was not implying that. This was a decision at a very early stage following the passage of the bill and its enactment by Parliament. And this was, of course, with great respect to a very experienced judge, looking at the Act in its very early stages and working on the basis that the development of the law in respect of this Act of Parliament will be incremental, with various cases coming before the court, as they still are. What Lord Judge said was that the direction given by the trial judge might be too favourable to defendants. Those are the words of the judgment, effectively. And if that is the case, well, it's to the advantage of the defendant. Yeah. And then the observation in the report, in the judgment rather, is that we need not pass further comment in relation to that issue in this judgment. Yeah. And so the words of Lord Judge, which are of significance, is that they need not be identical. And I would submit that what the court was doing was making the observation that this case was unique in the way in which Parliament had drafted the provisions. It was intended to afford protection to the most vulnerable members of society. The trial judge had taken this step in the early days of these cases, comparing the type of violence in his directions to the jury for the purposes of subsection 3, if I can call it 3. And all that was being done by the court in that early judgment was to make it clear that the circumstances did not need to be identical and that this direction might indeed be too favourable to defendants. And so I would, with great respect, submit that the court ought not to read too much into that part of the judgment in Khan.
But your submission would be that that example would be, that in the example that I've given, that the Lord Judge gave, that would fall within the offence.
Yes.
So you are very broadly interpreting.
I have.
Yeah. But you aren't able to help me with any exceptional circumstances.
I can't help it on a factual basis.
Well, what about this? Suppose that the father tells the daughter, you must be home by 10 o'clock. And sometimes she comes home late, and when she does, he beats her, right? So in those circumstances, the mother knows that if it's 10 o'clock, the daughter's not home, when she comes home, it's her job to protect the daughter from the father's beating, right? Suppose then the daughter comes home at 10 to 10, fine, but then the father, for some other reason, beats her because she was wearing an inappropriate dress, for example. Now, would that, the mother would say, She was home on time. I had no idea he objected to that dress. I couldn't have foreseen that he was going to beat her about the dress when she'd come home on time. Now, how would it apply in that circumstance?
She might well say that, give evidence to that effect, and the jury would have to be directed to consider that. But the reason why I have in our submissions focused already orally and certainly in writing on the most recent decision of the Court of Appeal in Jamal is that what is clear from that decision is that when one is looking at the awareness of the significant risk, it can be, may I start again? It must be coterminous with the unlawful act. The events which preceded it may well be sufficient to create awareness of the risk, but what the Act is requiring is awareness of a significant risk at the time of the unlawful act. And that would follow from that, to take your ladyship's example, that once the member of the household who decided that the child was going to be beaten even though she was 10 minutes early, to observe the actions of that person so as to create the awareness of the significant risk, either in the course of beating the child or immediately before beating the child, would be sufficient to satisfy all the sections, because the defendant will be put in a position of having to acknowledge, as a result of what was taking place, awareness of the significant risk, even though until then the father had never done this before. The duty would be imposed upon her to intervene to protect the child, which, let us assume, failed to do. But the act did not occur in circumstances which had preceded the events, and in those circumstances, or in that situation, the defendant will be entitled to argue before a jury that she did not have foresight of the consequences. The problem then for that defendant, which is the reason why we have expressed this other than in exceptional circumstances, is that the defendant is looking at the circumstances and experiencing them firsthand. And if a defendant sees her child, not late home, but then being beaten, not only is there the duty to intervene, but observation of the circumstances, situation on the ground, will tell that defendant, this act, this unlawful act, is occurring in circumstances which I can foresee. In other words, a significant harm is about to take place. Now, we submit no reason why 3 cannot be read in that way in the light of 1 and 2, to take your ladyship's example.
So that would be covered? You think that would be within the offence?
I do.
Yes.
Yes, I do.
So we're always finding examples that fall within.
We are.
I still come back to the point, if I may, that if you've got this exceptional circumstance exception, I'm not sure how we can certify the question of law in the affirmative. Because you yourself are accepting that there needs to be at least, as I understand it, you're going to say it's very rare, etc., etc. It's a very small cutback, but there is a cutback nonetheless. I mean, the jury cannot be directed in this way.
Oh, I wouldn't suggest the jury should be directed in this way. Right. What I will be submitting in due course is that Mrs. Justice Lambert directed this jury impeccably on the state of the law, derived from those 2 decisions of the Court of Appeal.
I accept that entirely, but the judge has to know what these words mean.
Well, he does.
Otherwise, there's no point in being here. So the certified question of law, I put it to you again, ought to be qualified by subject to exceptional circumstances on your submission to be coherent, I think.
Well, I have to confess I'm having difficulty in agreeing that point with great respect, my Lord.
Right.
I know from the discussion which has taken place between the court and myself that this is a troublesome issue. But we have introduced the proposition of exceptional circumstances in order to cover a situation which may not be capable of being anticipated readily, but will fall within those exceptional cases which come before the court from time to time, which judges have to deal with on a daily basis. And that's why the exceptional circumstances were introduced. But our primary submission in relation to, if I can just deal with it in this way, in relation to foresight, is simply this, that it's not appropriate to argue, or rather it's not accurate to argue, that 3 is rendered otiose by 1 and 2 because they have the effect of creating criminal liability. The reading that the appellant submits, should be introduced into the history of this legislation is that the Law Commission and Parliament were very concerned not to have an offence which was so wide that it created criminal liability in circumstances which the law did not really intend, because there must be scope for members of the household who are in fact entirely innocent and who have done their best in difficult circumstances. And while 2 would accommodate that in almost every case, in our submission there has to be a basis for accommodating the exceptional situation in which, for example, the elderly grandmother, she is aware of the risk.
But as I think you've said, it's not going to help going back to the elderly grandmother, because you've already accepted that would probably fall. There'd be a problem in saying that she could reasonably have expected to take.
Can I give you another example, just developing Lady Rose's example? Say the father is in the habit of beating the daughter whenever she comes home late. And the mother is aware of this. So we have a significant risk of serious physical harm being caused to V by the unlawful act of another member of the household. And D is aware of that risk. Now, say one night when she's out, he learns that she's pregnant, and when she comes in, he strangles her. Now, and that's
Comes in late or comes in on time?
well, comes in good time.
Okay.
But he strangles her. Now, I wonder if one might say there that everything is satisfied apart from D3, because the act occurred in circumstances of a kind that the mother could not have foreseen.
Well, the question for the jury would be, was the mother present at the time? On that example, I would submit, it accommodates a situation in which the mother may not be present, but knows that when the child gets home, she could be subjected to serious physical harm for whatever reason. If she's not in the house, she would avail herself of 2. She could not be expected to take steps to protect the child. If she is in the house and a witness to the events which must immediately precede or accompany the act of strangling, 2 imposes the duty upon her, and she would be caught by 3 if she was present as an observer, watching the events which immediately preceded the infliction of serious physical harm. So it would depend upon whether mother was present at the time.
if she wasn't, sorry to interrupt, if she's in the house, she's not in the room that he goes into to confront the daughter, and she doesn't know that the daughter's present or that the father's learned that the daughter's present. She's aware of the history that he beats her, she's aware of a significant risk of harm, but in that situation she couldn't have foreseen that these were circumstances of a kind that would lead to the unlawful act.
If she was not present, and
She's in the house, but she's not...
She's in the house, but not present. I would just introduce this point, first of all, if I may, that we would submit that whether it's an act of strangulation or serious physical harm by beating...
Well, let's say it's beating to make it...
Well, I was just going to say, in our submission, it's immaterial. The question is whether she had the foresight.
Yes.
The circumstances.
Yeah.
Mr. Smith, it's a slightly different point from me, if I may.
Yes, my lord.
It does appear that the certified question reflects a submission that was the prosecution submission below,
yes,
subject to the point about exceptional circumstances,
yes,
perhaps. And I'm wondering if that's terribly helpful, in that it may be that the real issue in the case is the question as to whether 3 is directed at the act or the circumstances.
Yes.
Lord, my submission is that that is the issue in this case.
And so the issue is not actually reflected in the certified question.
Yeah. It's arguably the case, yes. That was my submission to the court, which we in fact invited the court to consider a different certified question. Well, it wasn't entirely different, it was just expressed in different terms. But Lady Justice McKerr altered the proposal and the court produced this certified point. But it was effectively the submission that we had made. But the real issue in our submission in this appeal are those words so utterly different in paragraph 41 of the judgment of the Court of Appeal. Because the Court of Appeal, with great respect, fell into error in examining the circumstances from the point of view of the Act. They did not examine the question of whether the Act occurred in circumstances of the kind that were foreseen. And so those words, so utterly different, is where academic commentators have also made errors in trying to reason the way in which 3 should be interpreted. So one example is, of course, the 16th edition of Smith and Hogan, which introduced the question of if the defendant beats or kicks, what if the defendant poisons? And the earlier edition of Professor Orman's work concluded that a defendant could not be guilty in those circumstances if it was a case of poisoning. But therein lies the error that 3 is directed to foresight of the circumstances, not the Act. And that is repeated to some extent in the judgment of the court, with very greatest respect, because when the court came to deal with, at page 102 of the bundles, at paragraph 31 of the judgment, there are, we would submit with great respect, certain errors of reasoning in here and certain parts of the judgment which we would endorse. It begins at 31. We cannot accept Mr. Smith's submission, and one that Lambert J. apparently adopted in paragraphs 39 and 41 of her ruling. I just pause there to say that that is not the case. Mrs. Justice Lambert did not adopt in any way that submission, but she expressed it in different terms. Circumstances of the kind will necessarily encapsulate all and any serious harm caused or inflicted by any unlawful means if it occurs within the domestic setting. Then there's the OTO's point. But they endorse the paragraph from Smith, Hogan and Ormerod's criminal law at paragraph 32, which we would accept subject to one proviso, and if one reads it through, care must be taken to avoid the circumstances being interpreted too loosely. We would submit that must be correct. It is submitted enough that the prosecution can say that the circumstances are of a kind which involves general violence towards V in the domestic context, such that any unlawful act that causes serious injury to V in that setting is capable of being one that D2 ought to have foreseen. Now, once more, that is focused upon the unlawful act. It's the circumstances. So, subject to that proviso, we would agree with that paragraph. And then, this is the crux of the Court of Appeal's decision, 33. We are satisfied that the offence contrary to Section 5 was not and must not be so widely interpreted as to undermine the safeguards in Section 5.1d3, all of which must be given due weight. And again, we would acknowledge that must be accurate. But if I could just turn to this point of general violence, which is referred to in the 17th edition of Smith and Hogan and Ormerod. If there's a history of general violence, clearly one has to be careful that should not be interpreted too loosely when one comes to consider the issue of foresight, because one has to look first at whether there is awareness of a significant risk of serious physical harm. General violence may not reach that threshold. Abuse, and unfortunately is all too common, just simply pushing victims about in the household is one thing. That may not give rise to an awareness of a significant risk of serious physical harm or the duty under 2. So what we are submitting is that the certified point and the submission we made in the Court of Appeal below is that once the domestic context is such that there has been a history of serious physical violence resulting in serious physical harm, then that is the context to which 3 is directed. In other words, the circumstances in which the act occurred. And Mrs. Justice Lambert was quite correct in our submission in looking at the fact that as far as this victim is concerned, she had been the subject of a very serious burning injury conducted only 2 days before, which was such as to put every one of the respondents on notice of the risk of serious physical harm, the significant risk. And in those circumstances and in that context, Mrs. Justice Lambert concluded that that context was sufficient for a jury to consider item 3 in the Act. In other words, whether that context ought to have caused the respondents to have foreseen the circumstances, not the Act. And where the Court of Appeal fell into error in our submission are these words so utterly different, because in our submission it is immaterial that the act of administering glimepiride or causing the victim to ingest it in one way or another was so utterly different to the caustic burn.
So to go back to my example of the daughter coming home late, suppose the father in the past has always beaten her, but one time she comes home late and he does something else, makes her swallow something, bleach or something, causes her serious harm. I think you would say it doesn't matter that he made her swallow bleach rather than beat her. It was a risk of serious harm that arose when she came home late, and the fact that you might say that what he actually did was utterly different doesn't matter. It's still an act of...
That would be us.
Yes, okay.
And our submission is that, in practical terms, on looking at the jury's function and the judge's directions to the jury, what the jury will be told is to consider all the circumstances in which the act occurred. And those include the history of events, the nature of the relationship within the household, the circumstances which have caused the defendant to fear that there may be a repetition of violence. All those are factors which the jury is entitled to take into account under 3.
Yes, I mean, it's recorded that you accepted that you had to prove that one of the defendants had caused the urn.
Yes.
But was there also any reliance on the state that the victim was in terms of being emaciated and reduced from what she had previously been? Or was that regarded as part of the circumstances that indicated there was a risk of serious harm?
They were part of the circumstances. And so too was the history of hostility towards the victim, which had been simmering in the household in one form or another for a number of days, if not more than a week or two.
What was the evidence about the hostility?
There was the evidence was that she was to be sent back to Pakistan. One of the members of the family wanted that. There were complaints about the way she had not looked after her husband. She was being shunned by members of the household. One of them wanted her to go back to Pakistan, and in addition, there was an incident of minor violence in comparison because she had suffered an injury to the right ear, which was said to be traumatic in origin. One could even introduce the fact that this lady must, for a number of days, have been mobile in the house. That would fit with the medical evidence for the prosecution in terms of what this burn was. And during that time, nobody had sought assistance, medical help for her, and she had been denied medical help. These, we submit, are all the circumstances, so that when Mrs. Justice Lambert directed the jury on a 3, she directed them that it was their decision to consider all of the circumstances in the case, insofar as they bore upon the question of foresight. And that, in our submission, was an absolutely correct direction for one reason. It stems entirely from the guidance that was given by Lord Judge in those 2 cases of Khan and Ikram, who he emphasised in the judgment of the Court of Appeal that this was supremely a jury question. And so, in short, our submissions, Mrs. Justice Lambert gave absolutely the correct direction, and she refused the submission on behalf of the respondents that there should be some form of comparison or comparative exercise conducted between the caustic burn and the injury which she ultimately suffered from ingestion of glimepiride. And in our submission, that was the correct direction and is one that should be followed in every such case. The circumstances are for the jury to decide once the correct direction in law is given to them. And may I just return to a matter...
Can I just give you another example, if I may?
Yes.
Just to test, again, how broad you are reading this provision. Say we have a history of domestic violence by a father against his son, which has comprised regular beatings. So serious physical harm. They then get in on one particular evening into a heated argument about politics. And the father pulls out a gun and shoots his son dead. Now, is that the sort of... What do you then say?
I would say that it is immaterial what method or means is adopted to cause death in comparison with any antecedent event or history. It It is immaterial because if the defendant, who is alleged to be responsible for allowing, is present in those circumstances, what the jury must determine is, first of all, the risk, and that is obvious. Secondly, whether it's reasonable to impose the responsibility to intervene, and that's a question for the jury. But then thirdly, whether there ought to have been foresight. And once the production of that gun takes place, in the background of quarrels between the two of them, well, if the gun is fired, the mistake could be, of attributing the difference in terms of antecedent violence and the firing of the gun as significant in the context of 3. It's not in our submission.
Even though we've got, one might say, very different circumstances.
Yes, very different.
This is the sort of argument that anybody could have, that could get heated. The fact that it's no longer physical violence in terms of beating, that the father just pulls out a gun, you would say, well, that still falls within it.
I would.
I might have thought it would be a material circumstance whether the mother knew that the father had a gun or not.
It may be.
If that is a material circumstance, then it suggests that the nature of the act can't be left entirely out of account.
Well, I have not submitted that the nature of the act should be entirely left out of account. Yeah. We have submitted that it is only one of the circumstances. Yeah. So the nature of the act is not removed entirely. It is one of the circumstances in which the serious physical harm.
Let me make it simpler by saying the mother did not know. The mother did not know that the father had a gun.
But she's there when he pulls the gun out.
Yeah. But she's present. Yeah. Well, the mother would then say, I was aware of a risk of serious physical harm. I accept that. There was nothing I could do in the circumstances, and jury, please accept that it would be unreasonable to have expected me to intervene, and in any event.
So that would be 2.
Wait a minute, yes. Just in any event what?
In any event, I could not have foreseen. If it was pulled out just like that, and the...
and say it would have satisfied D2 so that there were steps that she could reasonably have taken, let's say there was some sort of delayed opportunity, you would then say what about 3?
I would then say that this is coming close to, if not satisfying, 3. Because the situation on the ground, if I may put it that way, is such that 3 is also triggered.
I do slightly worry about your insistence of the relevance of the presence of the other person actually at the event, because I could imagine that it quite often happens that one partner can't bear to watch the other partner punish the child. They know it's going to happen. They're too frightened themselves to do anything about it. So they do go into another room or go out of the flat so as not to be there witnessing it. But that can't then prevent them from being guilty of this offence.
No, it can't. Because the circumstances may be such that the awareness of the significant risk is established, foresight is established, and simply going out of the flat or house or turning a blind eye means that you haven't come within the protection of 2 in those circumstances. And could I also deal with one example which I think I've referred to already, the Court of Appeal mentioned in dealing with the utterly different point in paragraph 41 at page 104 of the bundle. At the very bottom of that paragraph, paragraph 41, I stopped, I think, at all cases will be fact-specific. Return to this. We would submit the Court of Appeal fell into error on this occasion as well. In this case, for example, if Ambreen had been forced to ingest a caustic agent, such as caused her sacral injury, then the misuse of the same or similar caustic agent could be evidence from which a reasonable jury may properly conclude that the act had been committed in circumstances of the kind that the defendants foresaw or ought to have foreseen. With great respect, the appellant has real difficulty with that example. But again, the Court of Appeal, however one views that example, the Court of Appeal was focusing again on the use of the caustic agent, the kind of injury, or the kind of harm, or the means by which it was inflicted.
But your criticism, as I understand it, isn't that they looked at those circumstances, which included the sort of agent that was used to poison her and the type of act. It's that they limited it to that. It's really the first sentence, yes, that the two are so utterly different, and therefore, as Lord Reid put to you a moment ago, it must also be relevant to consider the act. If a gun's pulled out and the mother knows nothing about a gun being in the house and had no awareness of it or ability to stop him using it, that must be relevant.
Yes.
So the last example is fine so far as it goes, but it doesn't cover all the circumstances.
Correct.
Is that fair?
Great respect, yes, I agree.
Would this be, it seems to be the difficulty here is that we have no idea in what circumstances the burn was caused or in what circumstances the medication was.
That is so much.
Yes, but the legislation has to be construed in a way that accommodates that situation, because that's likely to be a common situation, that all the members of the family either say nothing or they put forward some spurious explanation for what had happened, which the jury rejects.
Yes.
But one reading of the Court of Appeal's judgment would be to say, well, you have to infer then from what happened that the medication was administered in the same circumstances or in circumstances of the kind that led to the caustic burn, and because they're so different, it's difficult to infer that they must have occurred in the same circumstances, given that we have no idea what those circumstances were.
Well,
how does it work when, as here, you don't know what the circumstances were either of the previous injury or the act?
It works as follows from a practical point of view, prosecuting a case of this nature. This is one of those situations, the one which your ladyship has produced as an example, directly from the judgment. This is one of those situations in which the prosecution had to rely upon antecedent acts of violence. They had to do that because the prosecution had no evidence of what had actually taken place at the time when the burn was inflicted. And they had no evidence of how the victim came to ingest the drug glimepiride. So working from there, the prosecution's position was that you have a history in this case. But a matter of days before, this lady suffered this very serious burn. In the ensuing 2 or 3 days that followed, because of the way in which she was treated and neglected, and her position in the household, this small house in which they were all living, all the respondents became aware that one of their number had inflicted this very serious burn. And so, when it came to the unlawful act which resulted in the brain injury, the prosecution were entitled to rely upon the preceding circumstances, which demonstrated not only that one or more members of the household had inflicted that burn deliberately and unlawfully, but that all of them were aware of it, and they could all anticipate in those circumstances a repetition of serious physical harm at some stage, so that when the glimepiride was administered or ingested by her, at that point, that history was sufficient to create the awareness of a significant risk of serious physical harm in all of the respondents, and the jury so found. So that is how that would work in those circumstances. And that is why I have been anxious to draw the distinction between the case such as Jamal, in which all that was necessary was to demonstrate events which created the awareness of the risk at the time of the unlawful act, because that's what the act requires. In Jamal, that is the situation which existed. But in ATT, there had been a history of preceding violence, which was used evidentially to establish the significant risk of serious physical harm. And so that's in that situation, which is the situation the prosecution was in this case, it was essential that the prosecution established, and we acknowledged that during the trial, and the jury was directed to this effect, the prosecution must prove that the caustic burn preceded in time the ingestion of glimepiride. And so, of course, most cases of this kind do involve a history of violence towards children. Much fewer cases involve vulnerable adults. But when prosecutions reach trial, it's often the case that medical evidence reveals an underlying history of fractures or physical abuse. And the prosecution will rely on this history to prove that by the time the act occurs, which results in death or serious physical harm, the provisions of Section 51D1 are proved, awareness, against each member of the household, and then that underlying history serves the purpose of proving actual or constructive awareness of the significant risk, imposing the protective requirements of 2. And then it's necessary to consider, or the jury has to consider, foresight of the circumstances. And these are situations which are invariably fact-specific. One of the examples, I think, which arose in earlier discussion in Smith, Hogan and Ormerod, was the use of violence and then poison into the porridge. That takes an extreme example of physical violence, creating a risk of, or awareness of a significant risk of serious physical harm, and then the member of the household puts poison into the porridge and causes the child's death. The circumstances are that there has been an animus towards the child on the part of that member of the household. The child has already suffered significant physical harm at the hands of that member of the household. There may be much in the relationship which is of relevance, threats of violence and other things. And so when the jury come to consider 3 in that situation, it's not a question of whether poisoning the porridge is utterly different to the blows administered beforehand. It's a question of circumstances in which that act of giving poisoned porridge occurred.
And the Court of Appeal agreed, as I understand it, that Smith and Hogan example was incorrect.
Yes, and that we submit is a rather difficult part of the judgment to reconcile with paragraph 41.
Because you would say a very important circumstance here is the animus towards V,
yes,
as indicated by what had happened with the burning.
Yes. And the knowledge that they all had that it had been inflicted unlawfully and deliberately.
And I mean, as my lady pointed out earlier, that the fact that this poor young woman was emaciated and malnourished, unkempt and so forth, emaciation doesn't happen in the course of a few days.
No.
So there must have been something very wrong in the way she was being treated over an extended period.
She was extremely dehydrated, as chemical tests of her blood showed. Her hair was matted. She had lost weight, and she had been lying in urine and vomit for a significant period once the brain injury occurred.
Yeah.
So that was the whole context in which the trial judge directed the jury. As I've pointed out, and I know I've overemphasized this perhaps, and must be forgiven if I come back to it again, the element of awareness requires proof not necessarily of antecedent acts of violence or the threat of them, but the circumstances may be such where the prosecution are entitled to rely upon antecedent acts of violence and the infliction of serious physical harm to create the awareness of the risk.
But there must be a circumstance where there is violence for the first time, and as far as everyone in the house is concerned, it's totally unexpected, where they wouldn't be liable under this
Correct, yes.
section.
There may be a situation, for example, in which, I don't know whether this would assist in the exceptional circumstances, but I will deal with this, if I may, in this way. There may be a situation in which the husband, father, for the first time, a man who is known to care for his children, suddenly inflicts a blow with a hammer picked up from the kitchen table onto the head of the child, and the child dies. At the time when the hammer is being wielded, it may well be that the defendant is present and is aware of the significant risk of serious physical harm. And of course, the defendant may well be able to say, well, look, I passed the test in 2. I couldn't possibly have intervened to do anything about this. It all happened too quickly. But in any event, I could not have foreseen that my loving husband, who has been a model father, would do something like this. At this moment, it was beyond my contemplation.
And you might have a strict disciplinarian father who regards punishment as necessary in the upbringing of a child,
yes,
and who uses a stick to achieve that, and then uses a hammer 3 weeks later to kill the child. Mother knows about the punishment, but might be able to say, I had no idea, I had no way of foreseeing that he would use a hammer to cause that.
She could certainly, if I may put it colloquially, run that defence, and it may well be successful.
Yeah.
But in the example you've given, surely you wouldn't get past D1. D was or ought to have been aware of the risk mentioned in paragraph C. In the example you've given, that wouldn't be satisfied.
Well, with respect, it would. At the moment the hammer is raised, at the moment the hammer is raised, at the time of at the moment the hammer is raised, the risk will become apparent.
And you're saying that 2 would be satisfied?
2 would be satisfied.
Right.
And that would be enough, of course, for an acquittal. The jury wouldn't need to go further. because they will be directed at first instance. Have the prosecution proved 1? If not, not guilty. Have they proved 2? If not, not guilty. And then only then proceed to 3.
But if you've read in that the risk you're talking about is, oh, she can see the hammer's about to be brought down on her son's head, then you've automatically satisfied 3. The act occurred in circumstances of the kind that D foresaw or ought to have foreseen.
On those facts, that would appear to be the position. This is why I submit that in those circumstances, it's a question of fact for the jury, but the defendant could argue, how could I have foreseen, for example, that the blow would be inflicted?
But in the answer to the... Sorry, I was putting to you, but would you get past D1?
Well,
and you said, oh, well, if she's standing there and if there's a delayed opportunity so she could reasonably have done something, though in those circumstances, then it seems to me 3 would be OTOs.
It may not be OTOs. It would depend on all the circumstances. And those circumstances may be sufficient to trigger 3.
Well, I can't see what the circumstances are.
Well, I have, with great respect, my Lord, as you know, avoided, not deliberately, but have avoided being drawn into trying to answer the question because criminal cases, of course, are infinitely variable in the facts which arise. And all I'm submitting on that is that Parliament has introduced this safeguard with a view to ensuring that simply because somebody is aware of a significant risk of serious physical harm and hasn't taken, and 2 is not satisfied, they bring in the safeguard that the defendant must be proved to have foreseen the circumstances in which the act occurred. So if the hammer is raised, I agree, perhaps in the most, if you'll forgive me, I don't use this lightly, in the most exceptional circumstances, other than those. Once the hammer is raised, it's probable that 3 will be satisfied.
So there doesn't have to be anything antecedent, not any previous physical violence, not any threat of violence in the past that generates a risk. It's just at the event, which is the act. If the member of the household is there, they see what's about to happen, and they could have done something but failed to do something, then they're guilty of this offence.
Yes.
Except in an exceptional circumstance in which 3 would not be satisfied. Right.
I think your opponents are going to say, well, it's not much of a safeguard.
Well,
Keep on saying it's a third safeguard. You can't give us any examples of when it might actually bite. And the counter argument being put is, on your interpretation, it's not a safeguard at all. It's got no substance, is the argument, as I understand it.
No, that's not my argument, my Lord.
No, the argument put against you.
Yes, no, I understand the argument that's put against me. But I would submit it in these very simple terms that one can foresee a series of safeguards introduced by Parliament to ensure that, if you like, there is a rigorous route by which defendants ought to be convicted. And if one looks at the state of mind of a defendant, there is a difference between awareness of a state of affairs and foresight that the risk may eventuate. There's a clear distinction between those two in my submission. They're not the same. And so a person may well be aware of a significant risk of serious physical harm. But the question for the jury is, did that defendant foresee that this act would occur or in circumstances, sorry, I'll start again if I may. Did the act occur in circumstances which were foreseen, or of the kind which were foreseen by the defendant? And there is a distinction between knowledge of a risk and foresight that that risk will or may eventuate.
Now, Ms. Smith, we have been bombarding you with questions for the last hour and a half. You've got half an hour left, and we really must let you develop your submissions. Well, I know you want to refer us, you wanted to take us to the Law Commission report and to parliamentary materials. If there's any assistance to be gained, then by all means do so. Lord, and we will be quiet and let you develop your
argument. Well, my Lord, that's very, very, very kind with respect. Mr. Donkin is going to follow on one final point, so I need to give time for him. And I know that, oh yes, I have 2 minutes left. The way I would put the matter very simply, without drawing your Lordship's attention necessarily in detail, is that I would ask the court to look, please, at the judgment in Jamal, which is at page 773 of the main hearing bundle. I'll just pick it up myself on the screen. If I could just take the court through this. It is right, as the court in ATT pointed out, that no previous case, including ICRAM, has considered the correct interpretation of 5.1c. However, as appears from the judgment in ICRAM, each defendant took a point that the judge should have directed the jury more closely as to when on the evidence he or she should have been aware of a significant risk of serious harm. The question of what Section 5 required in relation to timing of proof of risk was accordingly central to the court's consideration of the directions which the judge gave in that case. As it appears from the highlighted passages of the trial judge's steps to verdict above, the Court of Appeal specifically proved the construction of the elements of the Section 5 offence under which the necessary proof of risk derived from the unlawful act itself. So that's one example. And then in paragraph 58, midway down, the restricted construction given to Section 5.1c by the court in ATT, that's antecedent events establishing the risk, was not necessary to the result of the appeal for the simple reason that on the particular facts before the court in that case, a prior risk of harm needed to be shown for all the elements of Section 5 to be made out against both defendants as allowance. The court said so in terms of the conclusion of the judgment. And so that deals with the inquiry made by Lady Rose in relation to the different sets of circumstances in which the risk is said, or a defendant is said to become aware of the risk. So that was one point I wanted to draw to the court's attention finally. And so I had framed the question, I hope I've done so accurately for the court, as follows: where, as on the facts of this case, the act which causes serious physical harm was so utterly different to the antecedent violence inflicted on the victim, is that necessarily fatal to proof of the requirement of foresight imposed by 3? because we contend that it's not, and that the Court of Appeal was in error with respect to that court in concluding significantly that the words so utterly different govern the judgment on the facts. I would like to just check, because I think it may be helpful to the court, the point that I was going to make, Lord Reid invited me to, about the Law Commission and the draft bill, in fact. Yes.
I was struck at the discussion of this phrase about foreseeing circumstances of the kind. The discussion of it is concerned with a completely different scenario that couldn't arise under the legislation as enacted. Yep. I'm thinking of the passage on page 490. It's paragraph 6.27 of the report. And it's the one place where I've seen a rationale given for the insertion of D3. That yes, it doesn't help us very much.
Although at 6.27, the Commission also made the point about foresight. The draft bill, I'd just like to check the draft bill, if I may, at 5:30.
But they're visiting a situation where the harm that ought to have been foreseen wasn't harm perpetrated by the person in the household.
This is the neighbourhood bullies point.
Yeah.
Yes.
Yeah.
And actually, that example, it would fail one because...
Yes.
Yes.
We used that example in the Court of Appeal, and the Court of Appeal said they didn't think very much of it. And on reflection, neither does the appellant. It has that problem attached to it that one would be satisfied.
But that's the whole point, isn't it?
Yeah.
That it was precisely drawn up to deal with what has now been dealt with more clearly, I think, by the fact that this person has got to be in the household.
Yeah. I'm wondering if anywhere else we find a rationale for D3.
Yes, but the requirement of being in the household wasn't present in the original Law Commission draft.
And 517 is the draft bill. And it's section 2 in the draft, where it's 517 into 518. The government amended, or didn't amend, sorry, adopted a different draft. The draftsman produced a different wording in D. The Law Commission's draft bill was the offences committed in circumstances of the kind that are anticipated or ought to have anticipated.
Mm-hmm.
And A, B, and D were effectively all taken by the government into its draft bill, and the vulnerable adult added. It was only in 2012 that serious physical harm was introduced in the amendment to the 2004 Act.
But I think the important point being made is that at that stage the bill didn't have that the D has to be a member of the same household as V, which is what the Law Commission was trying to deal with by the words in committing circumstances of the kind that are anticipated or ought to have anticipated.
Yeah.
So we don't really get any help on what we have to decide, I think, from the Law Commission work.
What we have submitted, you will derive help from, is the underlying evidence which the Law Commission considered in some detail in its consultation report and in the final report in 2003. because it's that which in our submission supports the conclusion of the trial judge, Mrs. Justice Lambert, that a broad and purposive construction is that which Parliament had in mind because of the concerns which had been expressed in evidence to the Commission and which led to the draft bill.
Are there any specific references you want to draw our attention?
No, they're very long documents, and with the greatest respect, I would suggest that they are valuable reading in the light of the problem which the Law Commission was grappling with, which is that perhaps 3 children a week were being unlawfully killed in the United Kingdom, and the common law principle, long-established principle derived from Abbott and Lane, was causing police forces to decide that it was impossible to pass files to the Crown Prosecution Service because they just lacked the necessary evidence under that common law principle, where members of the household were remaining silent or simply obstructing police investigation. So the introduction to the consultation report and the main report are particularly valuable documents, I would submit. So if I may hand over to Mr. Donkin just to complete our submissions, I'd be grateful.
Yes, thank you very much indeed, Mr. Smith.
May it please my lords and my ladies, I follow on what may be a less broad issue. It's the third matter raised within the agreed statement of facts and issues. And it's this, that there were, in addition to the findings of the Court of Appeal and the judgment, there were additional matters of criticism raised, yes, which are not the specific subject of that principal issue of statutory interpretation, and yet are within that judgment and remain unresolved. And because of the inclusion of those matters within the judgment, in those critical terms, but not expressly identified as relied upon by the court in allowing the appeals, it may be the case that the decision of this court in the appellant's favour would not necessarily be the end of matters. And by way of introduction, we submit that the criticisms made are not a basis for finding that the convictions were unsafe. The Court of Appeal could have said so if they were, and most expressly did not. And therefore, that if the answer to the certified question for your lordships and your ladyships is in the affirmative, then that can be the end of the matter in this case. We submit these are criticisms which can be dealt with by submissions in this hearing. But in effort to resolve all of the matters and striving for clarity in the case, if they were relevant factors which ought to be considered, the appellant wishes to respond to them. If they cannot be addressed adequately in these proceedings, then our submission is that the matter ought to be remitted to the Court of Appeal for clarification as to whether they amount to a basis for finding that the convictions were unsafe, given the ambiguity. And as a final point by way of introduction, the appellant simply raises this, that if it were to be remitted for the respondents to pursue further grounds of appeal against conviction, then it would be a legal curiosity that they are not matters that were raised by any respondent originally, appealing their conviction, and nor have they been pursued in writing at all before this court. Could I begin, please, by then referring in the key documents bundle to paragraph 16, which is at page 22. Within the appellant's written case. And the matter was introduced within the written case at that stage, identifying paragraphs 36, 38, 39 and 42 of the judgment, to which I'll turn in a few moments, if I may. But there are 4 key points to make. at the outset. These are criticisms made by the Court of Appeal of both the prosecution and the decisions of the trial judge. And those criticisms remain unresolved, but are not, it appears, the basis for concluding that the submissions of no case to answer ought to have succeeded, and therefore that the conviction should be quashed. The judgment doesn't state the extent at all to which these criticisms were considered by the court. Thirdly, the appellant invites this court to reach a judgment on those criticisms, and fourthly, to remit the matter back to the Court of Appeal if that submission is wrong and this court is not able to deal with the matters on the material before the court.
Forgive me, your second submission, Mr. Don.
Forgive me, that the judgment itself, forgive me, first submission, expressly these aren't relied upon to quash the convictions. Yes. And secondly, the matter is not clear and so is unresolved. And so at the risk of being sensitive to these criticisms, because they're unresolved, it may be that this is not the end of the matter, even if the certified question were answered. And clarity is sought today. And our primary submission is that matters can be dealt with today on the material available to this court. Effectively answered, and in our submission, answered in the following way. And this is the invitation the appellant makes. That firstly, those areas of criticism within the judgment were not the basis of a finding that the convictions were unsafe. The matter can be resolved because those matters within the judgment were not at any stage advanced on behalf of any of the respondents. Initially in seeking to challenge their convictions, or at trial, or in response to the documents exchanged in preparation for this hearing. Nor was the appellant, during those proceedings before the Court of Appeal, invited to make any representations in relation to these criticisms. They featured in the judgment without ventilation.
So were those criticisms also directed at what had happened at half-time, or were they directed more to the summing up at the end of the trial?
My lady, there's rather a combination. And when I come to them in turn, okay, if I may, some of them appear to be criticisms of the final directions to the jury, which of course are then removed from the question of whether the case should have been stopped at half-time, with Mrs. Justice Lambert's ruling on the submissions of no case to answer. May I come to that in due course when I come to each of those criticisms? The third ground or reason why the appellant says the effective answer can be given to these matters today is that where there were criticisms of Her Ladyship, Mrs. Justice Lambert, they are all adequately addressed, in fact, within her ruling and her directions to the jury, and so are groundless. And in any event, the fourth submission is that when there are matters of fact relied upon, or matters of interpretation of the evidence relied upon by the Court of Appeal, those are, in our submission, also baseless. And so the effective answer to these criticisms can be given today in these proceedings in accordance with the Court's powers pursuant to the Criminal Appeals Act as amended and the Supreme Court rules. Could I begin then, please, by turning to, within the key documents bundle, page 103 and paragraph 36. And if it's helpful, I propose to list the criticisms which the appellant has identified and then turn to each one in turn with a response to them. They seem to be that at paragraph 36, that this was a prosecution case riddled with evidential difficulties. At paragraph 37, the court describes it as disconcerting and seems to be troubled by reference to the civil standard of proof, referring to the balance of probabilities. And then also within paragraph 37, the court referred or indicated that what was required in a case like this was what is described as an intricate and evidentially tailored direction in relation to all components of subsection 5.1d, and that the direction should address also each possible causative act of commission of the unlawful act. Within paragraph 38, and then again at 42...
When it says disconcerting to see reference to the civil standard of proof, where was that reference?
There wasn't. There wasn't, my lady. The position is that, I think the indication is that the prosecution referred to that, or the implications referred to in opening and thereafter in the trial. The prosecution didn't at any stage refer to the civil standard of proof. The opening is within the main hearing bundle. And dealing with that point, because I can do so quite neatly, I hope, what was referred to was that the expert medical opinion resulted in experts indicating a probable explanation, to use that neutral term, probable explanations, which is a common situation in relation to reliance upon medical experts, and which was one of several features of the prosecution's case. And so the description there, disconcerting to see reference to the civil standard of proof in relation to establishing the unlawful act, what wasn't raised at any time by the prosecution, and what is also clear to see from the summing up, about which there is no criticism or complaint that has been made, the jury well directed on the burden and standard of proof. Very grateful. Page 150 of the main hearing bundle uses the word probable in the opening. And that's as close as matters came. Paragraphs 38 and then also 42 of the court's judgment introduced, again, without any ventilation during the proceedings, introduced, for example, the requirement of the offence of administering a poison or noxious substance, contrary to section 24 of the Offences Against the Person Act. And at paragraph 39, in fact, has suggested inadequacy of the direction from Mrs. Justice Lambert to the jury about the ingredients of that offence and the need to include the actus reus and the mens rea of the act of the offence of administering a poison or noxious substance.
Is this not a ruling on the no case to answer submission that's being criticised rather than the directions to a jury?
I'm sorry, my lord.
Is it not, the first line of paragraph 39, the criticism is of the ruling.
Yes.
And when one goes back to paragraph 38, one sees the ruling referred to. It seems to be the no case to answer submission ruling rather than the directions to the jury.
Forgive me. At 42, there is then reference to the directions. And so it's a criticism applied in both. And your lordship...
Well, the rest of the first sentence of 39, which is subsequently summed up to the jury.
Yes. Well, in relation to 39, the criticism there...
Just to be clear, 39, there's nothing in the ruling which indicates that she had regard to the evidence,
Yes.
which she subsequently summed up to the jury to the effect that. So in other words, she did include it in her directions. That's how I would read what's said in 39.
Yes, 39 appears to be concentrating on certain parts of the evidence with reference to Professor Pinkney and Professor Furner.
Yes,
and
am I right in thinking that the criticism in 39 is of the ruling on the no case to answer submission? It's
yes.
not a criticism of the directions given to the jury.
Yes, entirely, and forgive me, it's my error for not being clear. I introduced paragraph 38 and referenced the ingredients of the offence of administering poison or noxious substance. That's returned to at 42, when the court then criticises, in fact, the summing up that was given to the jury. I'm sorry for not being clear on that point.
But the summing up is being criticised as being tainted by the overbroad interpretation of 51D3, isn't it? Or are you reading further on?
Reading further on, my lord.
Right.
Over the page onto page 105, we have beginning with the second line. That is, we consider the judge should have specifically addressed the question of intent, the administration of a noxious substance, on the basis the jury did find one of the appellants to have administered the
This is a complete red herring. There was no charge under the 1861 Act.
Exactly, and when I made what may have sounded a bold submission, that these criticisms are in some regards baseless,
Yeah.
I'm afraid that's one of those examples.
Right.
So it may be most helpful for me to go, in fact, straight to the submissions upon them. Dealing firstly with paragraph 36 on page 103, suggestion the case was riddled with evidential difficulties. My lords and my ladies will recognise it was a complex case, and yet there was a body of medical opinion which was appropriately presented, all in favour of the Crown's case, and robustly tested. And it's difficult to see why the Court of Appeal has chosen to characterise it in that way, as riddled with evidential difficulties. The matter was tested fully, and the summing up demonstrates that all appropriate directions were given to the jury. And so the appellant would reject entirely that characterisation of the case.
And are you saying that was not ventilated in the course of the Court of Appeal?
That was not ventilated. Nor was it a ground of appeal. And I don't think, frankly, I can assist further. I could rehearse the elements and strengths of the case, but I'm not sure that will be of assistance. Paragraph 37 is the reference to the civil standard of proof, which I've already responded to. And I repeat, and I can give the reference in the main hearing bundle at page 199, that the jury was clearly properly directed on the burden standard of proof, and in any event, the convictions were quashed on the basis of a submission, no case to answer. There's no criticism raised, again, in challenging the convictions or in documents for this court of the directions on the burden standard of proof. Within paragraph 37, as well as concern raised about the civil standard of proof being introduced, the court, in the second part of that paragraph, which is page 103 of the key documents bundle, suggested that the jury would have required an intricate and evidentially tailored direction in relation to all components This is the 4 lines from the end of that paragraph. All components of subsection 5.1d. And then, if, as in this case, it was arguably one act or the other, and not a cumulative course of conduct that has led to death or serious injury, then the direction will need to address each possible causative act of commission.
You say it did all of that?
Well, it did, but there's a clarification or a qualification to be given that in these types of cases, as has been already mentioned today, saying precisely what has been done and how it's been done in these sorts of circumstances is something that evidently the prosecution commonly cannot do. And so requesting or indicating, as the court has, that what is required is an intricate and evidentially tailored direction to all components, including, if it was one unlawful act or another, a direction tailored to each possible causative act, imposes a burden which the prosecution isn't required to meet.
What does it mean, one act or the other? What was prosecuted was the administration of the drug, wasn't it? Not the caustic burn.
Correct.
So, I don't understand that
well,
first bit.
It may be that this is another shortcoming of the judgment. What our position is that it's not sound law and not a direction that is required, that the prosecution must be able to adduce evidence and the jury then be directed as to each possible causative act. The jury must be satisfied of an unlawful act and the circumstances in relation to an alleged allower, within section 5.1d and those requirements of the Act. But to describe it as such, at the end of paragraph 37, it isn't an appropriate legal basis in our submission. It's an error within the judgment. So the burden upon the prosecution is to prove that an unlawful act occurred. As best that could be done in this case, explained by the medical evidence, it was the administration of glimepiride. But greater focus on that is not required. The jury must simply decide that there was an unlawful act.
But this is going to the unlawfulness of the glimepiride administration, isn't it?
Yes, it is.
The idea is that Professor Pinky, or whatever,
yes,
said this is very, very rarely used as a poison.
Yes.
Therefore, it's more likely that she took it accidentally or it was given to her accidentally. But the jury rejected that by convicting.
Well, they did. It isn't very clear at 37 what the court is advancing. And the point about Professor Pinckney's evidence, which is at paragraph 39 on page 104, gives the impression that the court felt that that was a relevant consideration in this judgment. But again, in our submission, it can't have been the basis for quashing the convictions, because the criticism is that it's missing, as my Lord has just indicated, it's with reference to the ruling on the submission of no case to answer, and at which stage the judge is required to consider the prosecution case at its highest, which included Professor Pinckney's evidence supporting, well, forgive me, the evidence of a number of the medics, but including Professor Pinckney, that glimepiride, or an anti-diabetic drug, was the explanation for the victim's unconscious state and obtunded state. And so, whilst it's been flagged by the court, it's not appropriate to do so in our submission in criticism of the ruling at half-time in the case, when the prosecution case should be taken at its highest. It's a matter of evidence which goes to the jury along with all of the other combination of evidence in the case. And so it may not have been helpfully included in the judgment as a criticism of the prosecution case, not going to the principal issue about statutory interpretation or even going to the criticisms of the ruling at half-time in the case. Then return to paragraph 42. Within the judgment, it begins, even if we had concluded that Mrs. Justice Lambert did not err in rejecting the half-time submission, we would nevertheless have found that the summing up was tainted by the too broad interpretation given to subsection 5.1d3, the matter on which I don't follow, I don't make any further submissions. But to go on to say that the summing up did not sufficiently assist the jury as to how they should approach the task in hand. And then that is, we consider the judge should have specifically addressed the question of intent, the administration of a noxious substance, on the basis that the jury did find one of the appellants to administer the glymeperide. Well, again, that's importing into the Section 5 offence an ingredient which is not required. What is required is for the prosecution to prove that an unlawful act occurred.
But what was that the unlawful act, though, must constitute an offence under Section 5, subsection 5?
Yes, precisely.
But so you do have to prove that the administration of the medication amounted to a criminal offence.
Yes, of which it might have been a variety, including, for example, an offence of inflicting grievous bodily harm or of causing grievous bodily harm with intent. But the fundamental point when it comes to possibly criticising the safety of the convictions here, is that this is a matter which was never in issue in the case at all. If glymeperide had been administered to Ambreen in the circumstances, there was no argument but that that would have been an unlawful act. One could argue that the requirements of administering a noxious substance would have been demonstrated in any event, and the failure to address those wouldn't have an impact upon the safety of the conviction. But when examining the issue in the case and the issues for the jury and the safety of conviction, the absence of a specific direction about the mens rea required for administering a noxious substance has no significance or consequence in this case at all.
Certainly at the stage of a no case to answer submission, it seems from the ruling that the defence argument was that if it were accepted that hypoglycemia was the mechanism of brain damage, there was insufficient evidence that the glimepiride tablet had been administered by a defendant rather than by Ambreen herself, either deliberately or accidentally. And that possibility was dealt with by the judge in some detail.
It was, and part of the prosecution's case was that accidental, inadvertent, innocent taking of the substance was excluded with reliance upon the other counts on the indictment alleging perverting the course of justice, and that Ambreen had been resting in the bed, incontinent and so forth. Had the jury received the direction which the Court of Appeal advanced, again without inviting submissions and without it being part of any pleaded case to the Court of Appeal, it's difficult to conceive of the drug being administered without it satisfying the requirements of that offence, were that in fact necessary. And so when considering the safety of conviction, this point raised by the court again ought to have no bearing. And so, in terms of the overall position of the case, if Mrs. Justice Lambert's interpretation of the law was correct, if the answer to the certified question is affirmative, then the reason for finding the convictions unsafe, i.e. that the case should have been stopped at half-time, no longer remains. And in our submission, these remaining unresolved criticisms cannot be of sufficient weight, or of any weight, to cause any further concern about the safety of the convictions. And they can be resolved by this court on examination of the materials that are here and in light of the submissions made. And it's important that I conclude with one particular point, that, as your lordships and my ladies know, there is an agreed statement of facts and issues. The matters have been set out in the appellant's written case, and not in appealing conviction, not in responding to the application for leave to appeal to this court, not in the respondents' cases after the appellant's written case had been served, have any of these matters been raised as an arguable basis for the convictions being considered unsafe. If there is an arguable matter that can be raised, then we submit the matter ought to be remitted to the Court of Appeal again. But the reality is that these criticisms are of such a nature that this court can deal with the matters in these proceedings. Can I assist further on any points in relation to that third issue?
Thank you very much, Mr. Donkin. Yes, certainly.
Thank you. Yes, it's within the application for leave to appeal. Can I invite the court to make a note that at page 131 there are written submissions also, which I hope to amplify upon today orally, dealing with these criticisms.
Yes, yes. Thank you very much, Mr. Green.
My lords, my ladies, by the time the jury get to consider the words, the act occurred in circumstances of the kind that the defendant foresaw or ought to have foreseen, the matters which your lordships and your ladyships are already seized of having been proved, have been proved. And therefore, the appellant says essentially three things about that, if I can summarise them. First of all, what has already led the jury to get as far as little Roman 3 and those words will be enough to satisfy little Roman 3 without more, other than in wholly exceptional circumstances. Mr. Smith was tested by your lordships and your ladyships on that point. I'm not going to get into now the extent or lack of the extent to which he satisfactorily dealt with that. I would make this observation simply. Little Roman 3 is an ingredient of the Section 5 offence, which the prosecution must prove to the criminal standard of proof, not some qualifying or saving provision, or still less some sort of reverse burden type provision. Second, the appellant from time to time during the submissions advanced on their behalf encountered the phrase or varieties of it. This is supremely a jury question. Well, our answer is this: all ingredients of criminal offences in all Crown Court trials are supremely jury questions, subject to there being sufficient evidence to go to the jury. And here the Court of Appeal were simply saying there wasn't, on ordinary Galbraith principles of which the court will be well seized. And the third matter which the appellant raises to give little 3 colour, and therefore not to render it nugatory or otiose, it is by seeking to make a distinction between awareness of the risk existing and the foresight that it might eventuate. Can I...
Sorry, could you just say that?
Certainly.
To make a distinction between the... what was the...
The existence of the risk and the foresight it might eventuate.
Awareness of existence of the risk and foresight that it might eventuate. It may be most convenient if I take the court to the key documents bundle, the appellant's case at page 026. This foreshadows the submission that Mr. Smith orally made today in writing, paragraph 26. One of the Court of Appeal's reasons for rejecting the appellant's submissions was that if circumstances of the kind encapsulates all and any serious harm caused or inflicted by any unlawful means, if it occurs within the domestic setting, such a conclusion would render, and sets out the section and the subsection there, otiose, since by this stage of a jury's determinations, and you can read the rest of that paragraph, and I'll pick it up where it ends, the appellant takes issue with this conclusion for 2 reasons. They're little Roman 1. The wording of the second alternative means of committing the offence incorporates 3 safeguards designed to prevent an unreasonable burden of criminal responsibility being imposed upon members of the same household as the victim who might otherwise be convicted of failing to protect the victim. The combination of sections 5 subsection 1d, little Romans 1, 2 to 3, separately serve that purpose. And then this, and this is the matter which I foreshadowed and my Lady Rose asked me about a moment ago. Awareness of the risk is a distinct concept to that of foresight of the circumstances in which the act occurred. The former requires proof of an actual or constructive realization that a significant risk of serious physical harm to the victim exists at the time of the act, whereas actual or constructive foresight of the kind of circumstances in which the act occurred involves a realization that the risk may eventuate. Well, we submit that this distinction between the actual or constructive awareness that a significant risk of serious physical harm to the victim exists at the time of the act, that's little Roman 3 on the Crown's analysis, a distinction between that and actual or constructive foresight of the kind of circumstances in which the act occurred, involving a realization that the risk may eventuate, little Roman 3, that's a highly contrived distinction and doesn't make a lot of sense for 4 reasons. First, if we start with little Roman 1, as a matter of ordinary language properly used, a realization that a significant risk of serious harm exists at the time of the act necessarily includes a realization that the risk may eventuate. Put another way, anyone who knows or ought to know that a serious risk exists knows or ought to know that it may eventuate. Otherwise, it's not a risk at all in any material sense. So that's the first reason we say that it's a highly contrived distinction which does not hold together. Second, this. What the prosecution must prove at little Roman 3 is foresight of the kind of circumstances in which the risk might eventuate, not simply its eventuation. Third, by the time you get to little Roman 3, the defendant in question has already fallen foul of little Roman 2 in failing to take such steps as she or he could reasonably have been expected to protect the victim from the risk. Now, the appellant's analysis would mean that this was legislation requiring a person to take reasonable steps to remove or reduce a risk which she or he could not have been expected to be aware would eventuate. Now, our answer to that is that's not a rational or sensible imposition and would indeed impose an impossible burden. Parliament can, if it wishes, impose an impossible burden at pain of criminal sanction, but we submit that would require the very clearest of words to that effect. And it would involve, moreover, a requirement to take steps to avert a risk you've no reason to think will eventuate. And the fourth reason that this contrived distinction, as we characterise it with great respect to the appellant, does not make sense is this. If it really were the intention of Parliament to have two aspects to a defendant's state of mind in the way analysed by the appellant in the paragraphs which I've taken you to in the written case and spoken to again by Mr. Smith on the appellant's behalf today, and if those two states of mind were, one, actual or constructive awareness of a risk, and three, Roman 3, actual or constructive foresight that it might eventuate, you might expect, as a matter of drafting amenity, little Roman 2 and little Roman 3 to appear the other way round, and the requirement to take such steps as could reasonably be expected to be at the end as the last of the three elements to be proved. And then you would have awareness of the existence of a risk, little Roman 1, little Roman 2, foresight that the risk of which you're aware might eventuate, and little Roman 3, what you're expected to do once those previous matters have been established. That's not the way the legislation is structured here. Before we go to the Court of Appeal's judgment, given I started with the appellant's case and what we say in answer to the submissions made in respect of that provision by the appellant, it perhaps makes sense at this stage to begin to deal with the section of the appellant's written case which deals with external aids to construction. And you will see 5 external aids relied upon at page 28. And, of course, they start with the work of the Law Commission. The state of the law is headed at the time of the 2004 Act and the work of the Law Commission. We can start, because it's common ground here, with what the appellant says at paragraph 29 of the written case, 3 lines in. The perceived defect in the law which resulted in sections 5 and 6 of the Act was the impact of the common law rule that where 2 or more persons are charged with a criminal offence and the prosecution is unable to prove which one was responsible for the commission of the offence, in circumstances where they cannot be proved to have acted in concert, both must be acquitted. And of course, we agree that that was the original mischief behind the legislation. But in terms of the rest of the Law Commission work relied upon by the appellant, and indeed what appears in the main hearing bundle at the relevant pages, nothing is said about what was to become Little Roman 3. Of course, I accept that in the draft it didn't have to be a member of the same household, so I make no criticism of the commissioners in giving what in the result is an inapt example. But nothing beyond what is referenced at page 32 is said by the Commission in their document about what this will cover. However, what we do draw the Court's attention respectfully to is in the passage referenced by the appellant at paragraph 39 on page 32 of the key documents bundle. When we just leave for one side and excise for these purposes the example which has already been dealt with in dialogue between Mr. Smith and the Court, and pick it up, we are concerned, it reads, we are concerned that the person responsible...
Reading.
Oh, I'm so sorry.
No, it's my fault.
32. No, it's my fault. Key documents bundle 32. Paragraph 39, and the Law Commission in paragraph 6.27 of the Law Commission report is referenced. The first 5 lines set out the example which has already been dealt with by the Court in dialogues that developed with Mr. Smith. But then this, we are concerned that the person responsible should be at risk for those things of which he or she was aware or ought to have been aware and which have come about. We do not believe that such a person should be liable where what occurred was the commission of the same category of offence, but where its commission was not, nor could have been, reasonably foreseen. And then it goes on to say, the offence requires, therefore, that the circumstances are of a kind which the responsible person anticipated or ought to have done. Now, that perhaps poses rather than answers the question before this Court today. But what Mr. Smith, in the appellant's written case, has said at the following paragraph, it is not, we respectfully submit, a satisfactory resolution of the issue with or without the assistance of the Law Commission's report. Because what he says 3 lines down is this: while it is arguable that section 5.1d little Roman 3 may be surplusage in the context of section 5.1d1, and that both the Law Commission and the parliamentary draftsman could have achieved the same result from the combination of section 5.1d little Roman 1 and 2 alone. It seems from the Law Commission's example and the statements on behalf of the government in the House of Lords during the passage of the bill that the object was to provide safeguards against conviction by those who lack foresight for whatever reason, and then this, that a distinction between awareness and foresight was designed to achieve that end. And there the appellant in our submission appears to double down on their attempt at distinguishing between awareness of a risk and foresight of eventuation, which I've already dealt with and won't repeat what we say about that. We simply say, without repeating what's gone before, that is not anything that can properly or sensibly be inferred from anything that the Law Commission said in their careful and very full report back when that was...
Do they seem to be envisaging that what gives rise to the risk, or what creates the risk of which D is or ought to be aware, has to be something other than the raised fist at the moment of the act, or the raised hammer, that there has to have been some pre-existing risk that the person would raised their fist or raised the hammer, that the awareness that if someone's brandishing a hammer over someone's head, yes, there's a risk of serious physical injury if they bash them on the head with it, is, I mean, do you accept that is the creation of the risk by that at that moment is enough to satisfy the ingredient of the offence?
No, I mean, on Mr. Smith's analysis, the moment the hammer is raised above the head creates the risk of what you're aware, and indeed at that point engages Little Roman 2, which is you've got to do something about it, and if you don't, you're aware of the circumstances, which are that a split second later a hammer is about to be descended upon the hapless victim's head, and therefore 3 is also engaged. I mean, that cannot be what the Law Commission's thinking was on our submission. It's highly artificial, and indeed we return to what...
So when you say it's not what the Law Commission meant, are you also saying it's not what the words mean?
Yes, absolutely. Yeah, absolutely. I'm sorry, I was answering specifically. I wasn't sufficiently clear.
No, I just want to be sure I understand
yes,
your...
you're absolutely right. That's what we say. And we go back to the fact that, as the appellant concedes, in most cases you need an antecedent event to give evidence of a risk that you either were aware or ought to have been aware of. When pressed somewhat, Mr. Smith reverted, for understandable forensic reasons, to the Jamal case. In that case, of course, you had a sole perpetrator. It's difficult to see why this legislation was used for a sole perpetrator. And essentially, what the appellant in that case's argument before the Court of Appeal Criminal Division was, she hadn't put herself on notice of the risk of her own neglectful course of conduct. Well, you only have to say that out loud to see that that's ridiculous in the context of a single perpetrator case and an ongoing course of conduct by omission. Whereas in the ATT type situation and in the Sheikh case situation, you have one amongst 5 potential perpetrators. The Crown can't say who it was, and therefore to establish an awareness of risk is a matter of evidential reality, as ATT found, or as the court in ATT found. There needs to be an antecedent event which proves that awareness.
Well, now, I see the time,
yes.
Mr. Green. Can I just throw into the discussion
Certainly.
what if you perhaps look at over the adjournment, what Lord Reid, not me, but the other Lord Reid, said about construing criminal statutes in Brutus and Cousins. The reference is 1973 Appeal Cases 854 at page 861. It may be relevant.
Thank you very much.
And we'll adjourn then and resume at 2:00.